Good morning, Jonas. Good morning, everyone in and around the courtroom. This is case IT 0891T, the prosecutor versus Mićo Stanišić and Stojan Župljanin.
Thank you, Madam Registrar. Good morning to everyone. May we have the appearances, please?
Good morning, Your Honors. For the prosecution, I'm Tom Hannes. To my left, our case manager, Sebastian van Hooydonk. To my right, Joanna Corner, Alexis Demergen, Rafael La Cruz, Matthew Olmsted, and on the back row, a young lady, our intern, Lucy Eastwood.
Good morning, Your Honor. Slobodan Zečević, Slobodan Cvjetić. I'm sorry. Good morning, Your Honors. Slobodan Zečević, Slobodan Cvjetić, Eugene O'Sullivan, Ms. Tatjana Savić, and Andrea Zečević appearing for Stanišić defense this morning.
Good morning, Your Honors. Dragan Krgović, Aleksandar Aleksić, Michelle Butler, and Miroslav Ćuškić appearing for Župljanin defense this morning.
Thank you. I will let you in on what we were just, the issue on which we were just conferring. You would recall that yesterday, in the light of a concern, I would put it no higher than that this coroner expressed, she asked us to visit again the question of reserving some time tomorrow to tidy up any loose ends in terms of any legal submissions that are left unattended. And we would invite counsel during one of today's breaks to agree as to how much time you would need. And so we would know what to block for tomorrow.
Can I assist? I've spoken to Ms. Butler, who's going to be dealing with submissions of law, and at least on one of the aspects I know we've come to an agreement. And I believe certainly that another of the aspects, which relates simply to the way the burden of proof was expressed in the Stanisic brief, could be dealt with very simply, because the word any doubt crept in when obviously it's any reasonable doubt. There are just two other matters which I'm going to electronically speak to Ms. Butler about this morning, and it may well be, hopefully, that we can arrive at some agreement so that the only matters that will be left are the question of how to treat the Stanisic interview and the question raised by Mr. Olmsted in his address of the question of command and control and whether or not there can be two superior commands. So I would hope that it would be relatively short.
So do we, Ms. Corner.
Yeah, I can imagine. And I have many, many good reasons also for not wanting to be here too long tomorrow.
One other matter before I invite Mrs. Zečević to begin, I would just remind counsel as to today's sitting times. We would take our first break at 11:30, and the second session will run from 11:50 to 1:20, and the lunch break would be for an hour. And then we sit from 2:20 to 3:50, and the extended session takes us from 4:10 to 5:40. Yes, Mr. Zečević.
Thank you, Your Honors. Časni sude.
Your Honor, yesterday, at the very end of the sitting, I said what our closing arguments are going to address. Before I go into detail, let me make a few preliminary remarks. Everything that the defense announced in the opening statement was presented to the trial chamber and proven beyond doubt. A detailed analysis of all the evidence and laws adduced was presented in our final brief. Crucially, to this day, ever since Mićo Stanišić was interviewed in 2007, his defense has not departed from its initial position by a single centimeter. The statement made by Stanišić in the course of the 5 days of the interview with the prosecution, what the defense announced they would present in their opening statement, as well as the positions advanced at trial, they were all proven beyond doubt without any vacillation or variation, alternative explanations or similar. We were fully consistent in our position. I underscore this because the OTP position was quite the opposite. They advanced different positions at trial. They presented alternations of different positions, alternations of explanations, and alternations of their entire case theory that the prosecution argued at different stages of the trial. To illustrate this, let me recall that in their pre-trial brief, the prosecution do not say that the police was resubordinated to the army. Rather, they insist on coordination between the army and the police. Then, at trial, the prosecution argued, as did their experts, that there were cases of resubordination, but that they were relatively rare. Next, they argued that there was a difference between resubordination and coordinated action. Subsequently, they held that resubordination was carried out solely in the course of combat and not otherwise in other actions. 2 days ago, we heard yet another version, because at page 27340 of the transcript, in reference to P624 and the percentage of the MUP members who were resubordinated, Ms. Corner said, clearly the document says that they participated in combat, but it does not say that they were resubordinated in these actions. On the other hand, yesterday Mr. Olmsted said that MUP members were resubordinated whilst on the front in combat. Latterly, they argued that even when resubordinated, the police retained the capacity of authorized officials. They also continued having effective control over their members and had the right and the obligation to enforce discipline and run criminal investigations. The same applies to the prosecution final brief. Here again we have various alterations. Although in the opening statement I highlighted the fact that the prosecution completely misrepresented the context of the events in 1992, and although I noted with concern the extent to which the prosecution exhibited a lack of familiarity with the legal system and regulations of the former SFRY and BH, nevertheless, throughout the case, the prosecution chose to ignore these issues, and the same is true of their final brief. As an English philosopher and historian, Sir Isaiah Berlin, would put it, history is not only what happened, but what happened in the context of what could have happened. Clearly, the prosecution do not espouse this line of thinking, which is very true, because their view of history is monochrome and superficial. Let me remind you of some of the changes that the prosecution went through during their case. From the start of trial, the prosecution withdrew 91 witnesses and added 74 others. they had 2,061 documents on their 65-tier list, 509 of which were never presented, but 986 others were added. During the defense case, the prosecution my apologies. I'm sorry, I didn't say during the defense case. Some of the crucial documents were disclosed and tendered into evidence during the defense case without having shown them to their own experts or the numerous witnesses who testified precisely to these circumstances. And I'm referring to P2320, P2339, in other words, documents shown to Kovacevic and Lisica, but not to the OTP military expert. The OTP tendered a number of documents into evidence without having ever disclosed them to the defense previously. Despite our objections, in most of these cases, the trial chamber granted these applications and admitted the documents into evidence. We did not press the matter because we understand the position of the trial chamber as being that the prosecution have the duty to prove matters beyond a reasonable doubt, a standard that is higher than the one that the defense have to meet. However, there are several glaring examples that I will come back to later, which in our view have an impact on the integrity of the proceedings. Let me also remind you that in relation to the CHS, the prosecution tendered 6 different versions of documents as a result of the objections and omissions raised by the defense. They continued modifying and adding documents into the so-called database, even not only after the end of their case, but even after both defense cases ended on the 5th of April early this year. Specifically, in that group of documents supposedly supporting the victim database and among the documents that are alleged intercepts, there is a large number of documents that were admitted, in our view, in violation of Rule 95 of the Rules of Procedure and Evidence and the ICTY jurisprudence. I am sure that you will remember, Your Honours, how many times the prosecution challenged the authenticity of certain documents of the defence, only to establish subsequently that they too were in possession of these documents, but that apparently due to difficulties in conducting searches, they were unable to identify them. There were also cases where suggestions were made, although not directly, that the defense had put some sort of pressure on witnesses or contacted them before their testimony, all of which proved incorrect. Your Honours, this was just a short summary overview of the procedure, and I would like the trial chamber to note that there is an identical pattern of conduct that can be observed in the prosecution final trial brief. I must say that the final trial brief of the prosecution came as a major surprise to me 3 years into the trial, and after all the evidence adduced, because most of what we were able to hear and read at trial was simply ignored. At first glance, the prosecution brief appears to be a coherent document with a great many references, but that is the case only at first glance, since there is a considerable number of cases where the reference given does not correspond to the conclusion drawn in the paragraph involved. In some cases, it is probably an error. In other, it is evidence misconstrued. Still other, erroneous interpretation. there is a considerable number of paragraphs where evidence as a whole is completely ignored or disregarded or construed in a way that does not have any foundation, or there are paragraphs where all these elements appear combined. The impression gained from reading the prosecution final trial brief is that the events seem to have happened in a vacuum, as there is no mention of a cause and effect relationship between the various events. The events appear to be unfolding, according to the prosecution, without any context whatsoever. Especially perilous are the following examples that I urge the trial chamber to pay special attention to. It is only natural, given the nature of this procedure, that on account of interpretation or a confusing question, a witness would misunderstand the question put to him. As a result, when reading the witness's entire evidence, one can tell that at some point the witness said something that was quite the opposite of everything he had been claiming all along. I think that Ms. Corner spoke of that yesterday. I think that it is inappropriate on the part of the prosecution to quote precisely these portions of evidence where it is obvious that the witness concerned misunderstood an issue. For this reason, I would like the trial chamber to pay special attention to such cases that I will specifically refer to in the course of my closing arguments, and to consider, when assessing the evidence as a whole, the testimony in its entirety and not the one lone sentence quoted by the prosecution. From the very start of the prosecution brief, the introduction, there are several examples of the OTP's lack of consistency that I will stress. At paragraph 2, the prosecution argues that the police was the only organized armed force in Republika Srpska at the very start. Here the prosecution exclude the territorial defense, although in their pretrial brief at paragraphs 96 and 105, they argued that the police, together with the TO, was the only armed formation. It is a fact that during the prosecution case, a significant amount of evidence was adduced about the existence, functioning and arming of the TO even before the RS MUP came into being. At paragraph 4 of the final brief, the prosecution were commenting on the position of the defense that the crisis staff had an impact on the functioning of the RS MUP, say, such statements are easy to make in the absence of accused persons who were members of these bodies. This comes as a surprise in view of the fact that in this courtroom we heard dozens of witnesses who were members of various crisis staffs, as well as members of the RS MUP who were crisis staff members ex officio. In that same paragraph, the prosecution go on to explain that there is overwhelming evidence which indicates that they all had a common goal. They argue that everything was bent on furthering the alleged criminal plan, although all the witnesses claimed that the common goal was to defend the country, which is only logical and is a paramount goal of any country. Yesterday and the day before yesterday, at pages 10 and 11 of yesterday's transcript, a similar baseless statement was reiterated. The prosecution said that the defense had the advantage of being able to shift the blame on the deceased, specifically Todorović and Drljača, and the prosecution were evidently oblivious of the fact to the fact that they themselves sought the admission of portions of Todorović's testimony pursuant to Rule 92 Quarter, and this is something that the defense subsequently did in respect of other portions of testimony. Likewise, it was the prosecution who, for the most part, sought the admission of the documentation related to Simo Drljača. On the issue of Stanišić's interview, I refer you to what the prosecution had to say at paragraphs 10 to 12, whereas the paragraphs of our brief dealing with this issue are 15 to 17. The prosecution suggests that the trial chamber should trust only Stanišić's incriminating statements and not the rest. This statement by the prosecution escapes comprehension, especially in view of the fact that it was the prosecution who sought the admission of Stanišić's interview and not the defense. And that, as I said yesterday, it was done through a bar table motion. They relied entirely on that document for the truthfulness of its contents, as was the case with all the other documents included in the bar table motion. This is an example of a striking lack of consistency on the part of the prosecution, because the bar table motion does not contain any sort of submissions of the kind that were set out in the final brief. If the prosecution had any sort of reservations as to the truthfulness of this document, then by the very nature of things, they would not have sought its admission or relied upon it. The prosecution team, led by the experienced lawyer, Mr. Tiger, interviewed Stanišić over the course of 5 days, showing him documents and asking that he answer questions. He answered questions and explained the contents of various documents and why they were written. And he said that all of his answers, as well as the entire contents of the interview, can be used at trial. This is something that the prosecution ultimately did. And at paragraph 15 of our brief, we say what the bar table motion had to say about this interview. Also at paragraph 16 of our brief and footnote 22, we cite examples where the prosecution, clearly relying on this interview, in their pre-trial brief, in the opening statement, and in the course of trial, spoke of this. Yesterday, Ms. Corner cited the interview and read certain portions of it, only to say at the end that they were not relying on that interview. Your Honour, I am aware of the fact that my knowledge of the adversarial procedure and principles is very limited, and I offer my apologies. However, I believe that one of the principles that should stand is that the defense should be put on notice of the nature of the prosecution case, and that it is on this basis that the defense would be able to build their case. If the prosecution continue to rely on a piece of evidence throughout, only to say at the very end that they would no longer be relying on it, I don't see how the defense would in that case be able to answer the prosecution case. In that way, the defense would in fact be misled. A small aside. Yesterday, when I quoted the jurisprudence of the Tribunal on this issue and similar issues, I neglected to underline that in all the 3 cases that I cited, the Milutinovic et al., Perišić and Popović et al. Cases, the interviews with the accused and the OTP were introduced as prosecution exhibits. In 2 of these cases, it was done identically as in this case, i.e. through a bar table motion, and in Popović through a prosecution investigator who interviewed the accused. The next example I want to refer you to is in paragraph 13 of the final trial brief of the prosecution and relates to the so-called insider witnesses. Let me remind you that in the pre-trial brief, the prosecution, at paragraph 18, the prosecution argued that, and I quote, the testimony of these witnesses would allow the trial chamber to clearly see the joint criminal enterprise charged by the prosecution, its goals and methods, its members, and the role of the accused in the joint criminal enterprise. As you know full well, their testimonies, in fact, confirmed quite the opposite. Yet again, the prosecution insinuate in a manner that I have to say is highly improper that the reason why witnesses allegedly changed their previous statements was the discussions they had with the defense before their testimony. If such an insinuation was not inaccurate, unfair, and unbefitting of fellow members of the profession, I would consider it a true compliment. The ability to use 30 minutes to meet with a witness for the first time and manage to persuade him to change his testimony would indeed amount to a supreme skill. Furthermore, the prosecution suggests that when assessing the probative value and weight of these testimonies, the trial chamber should bear in mind a number of factors, among others, the motive for giving false testimony. Such a patently inaccurate statement requires some attention. In fact, the prosecution engages in an impermissible speculation, in this case in view of the facts. The prosecution are oblivious to the fact that although the trial chamber repeatedly called on them to disclose previous statements or interviews of the viva voce witnesses, the OTP refused to do so, unlike the defense, who disclosed all the interviews and statements of defense witnesses to both the prosecution and the trial chamber. What is more, we even suggested that the OTP interviews of defense witnesses be admitted into evidence under Rule 92 ter, an application that the trial chamber denied. Accordingly, Your Honour, the interviews that the prosecution claim contain these inconsistencies in witness statements are not before you at all. So, in fact, you should, if I may put it that way, make a leap of faith and trust the prosecution when they say that there are inconsistencies and formulate your opinion of the value of their testimonies accordingly. Let me recall that in the cases where the prosecution showed their witnesses the previous interviews, the witnesses gave clear and compelling reasons and explanations accounting for certain discrepancies in their answers. In fact, the very the fact that the witnesses, that there are inconsistencies in their statements is an indication that they tell the truth as established by the ICTY jurisprudence in some earlier cases.
Although the interpreters have not indicated they have a problem, I suspect that you're going a bit too fast. So please bear in mind that that you have to be interpreted. Thank you.
Thank you very much, Your Honor. I'm sorry if I apologize to the interpreters if I'm rushing. I will keep a slower pace. Samo u jednom slučaju, koliko se sećam.
As far as I recall, there was only one case where the prosecution asked that one of their witnesses be declared a hostile witness. To the best of my recollection, at no point during the trial did they suggest that any of their witnesses were providing a false testimony. This speaks volumes about how founded this OTP position is. The prosecution spoke about this yesterday at page 10 of the transcript and reiterated their position from the final brief. I do not agree with the assertion that the witnesses considerably changed their statements. In my view, it was the case of the prosecution teams who interviewed them who were either not prepared sufficiently for these interviews or, for reasons known to them alone, failed to put crucial questions or address material facts. The trial chamber should always bear in mind that under such circumstances, the statements of all these witnesses have to be interpreted or translated, and then they become documents. Let me remind you of the case of witness ST-187, who testified as a 92-ter witness. The defense interviewed the witness, and it did so several days before he took the stand, because the prosecution insisted that we do it that way in order for them to have an opportunity to additionally prove the witness for his testimony. In his testimony in the Krajnik case, the witness said that he was ordered to send the dispatch of the 31st of March 1992, which is P353, by Stanišić. The defense questioned the witness about this fact, and he reneged it, and he testified as much in your presence, Your Honor. The prosecution clearly knew that the defense would be challenging this portion of his testimony from the Krajnik case, because Stanišić himself denied it in his interview. Instead, what happened? The night before the witness was to appear, the proofing note did not contain a single word about this particular change, and the defense counsel sent an email to the prosecution, was sent on this new development. And you know, I'm sure you remember that on the following day we had lengthy discussions about it in court. However, the gist of the matter is as follows. The prosecution never asked the witness to confirm this fact, although they knew that he spoke to the defense and that it could be expected that the defense would be questioning him about it. This is a perfect example of the selective approach adopted by the prosecution, which I believe is evident throughout this case. The prosecution developed a case theory suited to their own needs rather than the underlying evidence, and every interview that was conducted with witnesses was aimed solely at confirming facts from that imagined theory rather than eliciting credible information. This is quite evident and can be readily seen in the contents of the final trial brief of the prosecution. What poses a veritable problem for the prosecution is the fact that all these so-called insider witnesses were compelling. Their testimonies were consistent with those of other witnesses who testified to the same issues, and more importantly, they were fully consistent with the evidence, both of the prosecution and the defense, with orders, minutes from meetings, and contemporaneous reports. That is the only reason why, at present, the prosecution is asking that you, Your Honours, trust their witnesses in cases where it suits the OTP theory and to mistrust them where that is not the case. In their final brief, the defense explicitly cited the portions of testimonies of specific witnesses that cannot be accepted and substantiated it with reasoning and evidence. We are convinced that the trial chamber will, as stated on a number of occasions, assess the totality of evidence and base their conclusions on that. We also believe that the evidence can only be assessed in its entirety, and we seek that the testimonies of these witnesses be assessed in correlation with the evidence and testimonies of other witnesses on the same issues. After all, it was the prosecution who chose the witnesses to call in their case and to base their case theory on. If they had any reason to doubt the veracity of statements of these individuals who are now being represented as alleged members, or as members of the alleged joint criminal enterprise, then they should not have called them to begin with. now that we're on this issue, I'm sure that the trial chamber also observed that the prosecution did not call a single witness from the MUP of Bosnia and Herzegovina, a Muslim, to possibly refute the facts that Stanišić related in his interview. In the course of his interview, Stanišić stated who were the colleagues from the former MUP of Bosnia and Herzegovina he spoke to, what they spoke about and when. At least several of them were mentioned during the interview, and they were mentioned countless times during trial. Deli Mustafić, Hilmo Selimović, Mr. Pušina, Kemal Sabović, Avdo Hebib. As far as I know, all these witnesses are alive and well and within easy reach of the OTP. These witnesses could easily have testified to the facts related to Stanišić's character, his alleged connections with the SDS, his alleged membership of the JCE, the MUP, the split in the MUP, and other facts on which the prosecution built their case. At any rate, the prosecution would not have had to instead prove their points with evidence that had significantly less weight by interpreting their probable contents. Nevertheless, the prosecution never invited any one of them and chose to introduce Stanišić's interview as evidence. Yesterday, or was it the day before, that Ms. Corner said at page 42 that for obvious reasons you were unable to hear the testimony of any of the members who were Muslims, members of the MUP BH. I don't see why that would be so obvious. The only reasonable explanation for such a position would be that in their contacts with the OTP, these individuals confirmed what Stanišić said in his interview, and the prosecution did not call them because their testimonies confirming Stanišić's interview would probably have fatal consequences for the prosecution case. I suppose that was the only reason why they chose to call the so-called insider witnesses, so that in the event that their testimony did not suit them, they could suggest that the trial chamber should reject their testimonies in their entirety. After all, this is what they did in their final brief and what they reiterated in their closing arguments. I will remind the trial chamber that several of the witnesses called by the defense were originally on the prosecution list, but were subsequently withdrawn by the prosecution. Let us now move to the contents of the prosecution final brief. As a follow-up to what I said so far, I will cite several examples of the lack of consistency on the part of the prosecution when it comes to what they say in their final brief and the evidence that they adduced, or their misinterpretation in relation to the JCE. On the issue of the JCE, at paragraphs 14 to 51, the prosecution speak about a clear pattern of conduct, and the defense deals with these issues at paragraphs 89 to 97 of our final brief. Obviously, all these various occurrences that the prosecution lists are viewed in full isolation and outside of the context of the events in the former SFRY. Once the right to self-determination was recognized to the peoples in the Republic of Croatia, Slovenia and Macedonia, under that same principle, these rights had to be guaranteed to the other peoples, including the Muslims, Serbs and Croats in Bosnia and Herzegovina. The gist of it is that there are reasons that are of a completely different nature, but that are equally rational and valid. There are other causes of these events that need not necessarily be related to any sort of criminal plan. Therefore, regional associations were created, such as the ARK, or Herceg Bosna, which was created by the Croatian people at more or less the same time, in a manner that was quite legitimate and in accordance with the constitution and laws. The Muslims were in favor of a unitary Bosnia-Herzegovina and did not create regional associations. Certain Serb regional associations, such as Northern Bosnia, have never really become operational, and this is something that the prosecution do not dispute. Therefore, to assert that regionalization is part of the plan is something that is untenable. How can one account for at least two facts that are contradictory, namely that the Croats themselves were creating an identical association at the same time, and they were definitely not a part of the plan, and the fact that some of the Serb regional associations that were allegedly so important to the plan were not established at all or did not become operational. Similarly, the creation of parallel structures need not be related in any way with the alleged plan. The evidence in the case file indicates that this was a direct result of the violation of the constitution committed to the detriment of the Serbs in Bosnia-Herzegovina, and that the formation of the Assembly of the Serbian people in Bosnia-Herzegovina and the subsequent plebiscite were a democratic response on the part of one ethnicity to the fact that their legitimate rights were denied, as testified to by a number of witnesses cited in paragraphs 93 and 97 of our final brief. Propaganda and a climate of fear are tools employed by all the media, regardless of the ethnicity they belong to, and invariably directed against members of other ethnicities. And that trend, unfortunately, emerged as early as in 1990 with the emergence of national parties throughout the SFRY, and therefore this need not be the only logical explanation that was the part of an alleged plan.
I don't want to delve into an in-depth analysis of the strategic goals which are mentioned by the prosecution, at least in 3 places in the final brief. I'm just going to present the facts which clearly show that the conclusion by the prosecution is not the only rational explanation. Namely, those strategic goals were defined for the first time in mid-May 1992, when the war had already started. The list of those goals was only published in 1993, and then that list became an official document when it was published in the official gazette. In the prosecutor's reference with paragraph 43, it is stated, or rather, one part of Karadžić's speech is quoted, and in that speech he defined the goals, and that speech was taken out of the context because Karadžić says in there that the strategic goal of the SDS was a tripartite Bosnia and Herzegovina, and that goal had already been achieved because it had been accepted by the European Union, by the international community, by Cutilero's agreement, and this is a fact. Strategic goal number 1 is quoted by the prosecution in its incomplete form because it omits to mention the word state. In the speech, it is referred to the state separation from the other 2 people, i.e. the creation of institutions in all of the 3 entities in Bosnia and Herzegovina, which I believe was a legitimate right of the Croatian and Serbian peoples in Bosnia and Herzegovina. They were entitled to taking their destiny into their own hands after the violation of the constitution at the Assembly of Bosnia and Herzegovina in October and December 1991. In paragraphs 52 to 62, the prosecution speak or provides the background for the creation of the RS MOP, and the defense deals with these issues in paragraphs 44 through 88 and 98 through 161 of their final brief. Again, there is a very reasonable and very rational explanation for the creation of the RS MOP, which doesn't have to do anything with the joint criminal plan. Namely, if a tripartite federation was created based on negotiations and an agreement with the support of the European Union, and if the entities were given the right to form certain bodies, including the Ministry of the Interior, within such an organization of Bosnia and Herzegovina, then embarking on that was part of a legitimate process which had been agreed. The Dayton Agreement, which was signed in 1995, provided for the identical organization which still exists. I'm sure that the prosecution do not want to apply the same standard to the Dayton Accord, and they don't want to put the Dayton Accord into the context of the JCE. In light of what the prosecution said yesterday about the plan of the division of the MOP, I would like to remind the trial chamber that the international community had started negotiating with the warring parties in the former SFRY already in the summer of 1991, and that the negotiations about the future organization of Bosnia and Herzegovina started in September 1991 at the latest, and after that Badinter's Commission started making conclusions from November 1991. In other words, Cotillero's plan and Lisbon's agreements were actually only the end of the process which was launched at least 6 months before that under the auspices of the international community. Moreover, in paragraph 63 to 68, the prosecutor speaks about members of the criminal enterprise and provides conclusions without any references in the footnotes, i.e. based on the same sort of understanding and theory which the prosecutor himself built without relying on any evidence, on any piece of evidence of 4,500 or the transcript pages of over 27,000 pages. The day before yesterday, Mr. Dermijan said on page 14 that the JNA systematically distributed weapons via the SDS within the framework of a well-orchestrated plan. However, on page 54 on the same day, Ms. Korner said that even before the Army of Republika Srpska had been established on the 12th of May, the MOP was the only armed force on which the Bosnian Serbs could rely at the moment, because they didn't know whether the JNA would help them, whether the JNA would place themselves on their side in case of conflict. The way I see it is the claim that the JNA was not part of the plan, so I'm no longer sure what the position of the prosecution is on this issue. In the part of the prosecution brief entitled Implementation of the Alleged Plan, paragraphs 69 through 85, I believe that one should remember the findings of the trial chamber in the Galić case as a preliminary legal issue. In paragraph 199, it was established that the armed conflict started on the 6th of April 1992, which is also the date that the War Crimes Tribunal in Bosnia and Herzegovina accepts in its decisions. For example, decision number X-KR-05/58 and the appeals decision X-KRZ-05/58. In paragraphs 82 and 83 of their final brief, the prosecution speaks about the reports on the war victims by expert Eva Tebal and the claim on the number of victims among civilians and soldiers. I believe that these claims have not been documented and cannot be relied on in view of the serious faults of the CHA document that we came across. It is indicative that the expert Mrs. Debo, which is also an employee of the prosecution, did not have an opportunity to take a critical stance and evaluate the correctness of the information that the so-called database of the prosecution dealing with the victims. When it comes to the prosecutor's final brief, where the prosecutor deals with the implementation of the alleged plan in municipalities, I will just provide a brief comment on those municipalities which are not covered by the Župljanin indictment, because I believe that the Župljanin defense will deal with that in great detail. Let me start by saying that there is no proof, that there is no order by the RS MOP on any activity regarding the takeover of municipalities. If the statement were by the prosecution were correct, that the MOP was a hierarchical structure and that allegedly there was a clear pattern of conduct with regard to the takeover of municipalities, how is it then possible that there is no single order or instruction by the RS MOP in that regard? Your Honours, the first municipality that the prosecutor deals with is Pale. And you saw from the evidence that Pale is one of the municipalities of the city of Sarajevo. During the proceedings, it was established that a lot of Serbs, fearing the situation in Sarajevo, fled Sarajevo and ended up in Pale. Koroman was the chief of the SJB, and he was appointed by Minister Deli Mustafić. It is a fact. You also heard evidence and testimonies that the takeover of the police station at Pale was part of, or rather, response to the situation at the SJB in Stari Grad, from where Chief Jahić expelled Serbs from the SJB. And all that happened before the MOP of the Republika Srpska was even established. In paragraph 104, which deals with the 400 people from Bratunac which were brought to Pale, the allegations in this paragraph were refuted by the testimony of another prosecutor's witness, which was explained in paragraph 500 of our final brief. Paragraphs 109 to 124 of the final brief of the prosecution deal with the municipality of Bijeljina. The defense brief deals with these issues in paragraphs 487 through 494. Also, in paragraph 114, it is the statement in that paragraph is not founded, since Jesrić was appointed the chief of the SJB, or rather reappointed again by Minister Deli Mustafić, and then from the position as the chief of the SJB, he became the chief of the CSB in the MOP of Republika Srpska. P1409 speaks about the temporary appointment starting with the 1st of April, whereas the appointment of the 15th of May is related to an order which was issued on the 15th of May, and it is incorrect that appointment was permanent. We are explaining that in detail in our brief in paragraphs 205 and 206. The fact is that Ješurić was soon removed from that position, and the prosecutor does not challenge that fact. Please look at P876. In paragraph 116, dealing with the murders of Muslims in Bijeljina and the murder of Muslims and the families by Duško Malović in September, the allegations are incorrect. If we look at what witness Adnan stated, and please look at document 1D97, we explain our position in our brief in paragraphs 332 through 333 and 338 through 384. I will revisit this issue later. And now on to paragraphs 117 through 119, where the prosecutor deals with Batković camp. Your Honor, the police had nothing whatsoever to do with Batković camp. They did not have authority. They did not have any knowledge about that. Witness Annan testified about that, and there is also evidence 1D730 that specifically confirms that. We deal with this issue in our paragraphs 503 through 506 in our final brief. The adduced evidence also confirmed that it was the police that liberated Muslims from Mauser's detention and arrested Mausers, and we speak about that in paragraph 343 of our final brief. In paragraphs 136 through 144, the prosecutor deals with the issue of Manjača. The defense deals with these issues in paragraphs 503 through 506. Your Honors, numerous reports about the work and the interviews of military investigators in Manjača were submitted to the military security bodies. None of them were ever submitted to the MUP, and this all arises from the evidence listed in footnote 988 of our final brief. When it comes to Zvornik, the municipality of Zvornik, the prosecutor deals with that in paragraphs 145 through 156, and the defense deals with these issues in paragraphs 331, 472 through 486, 351 through 365, and 597. And now on to Visegrad. The defense deals with the issues of Visegrad in paragraphs 373 and 469 of our final brief. The defense deals with the issues of Gatsko in paragraphs 466 through 471 and 517 of our final brief. When it comes to Visegrad, I would like to say that the prosecutor deals with the takeover of Visegrad, and that the prosecution's allegations are a fabrication. The fact is that Visegrad was taken over by the JNA, and that there was a clear military need to do that. Namely, several individuals occupied the dam, and they threatened that they would open the dam and that all the settlements downstream of the Drina River would be flooded. In paragraph 182 of the prosecutor briefs, the allegations about the Obrenovac detachment are incorrect. Obrenovac, Your Honors, is a city in Serbia, some 30 kilometers away from Belgrade. indeed, Milan Lukic was a policeman there, but he was a member of the MOP of Serbia, and the RS MOP did not have any authority whatsoever over its members. For that reason, that group was attached to the paramilitary group White Eagles, as the prosecutor alleges. On page 50, Mr. Olsen quoted witness ST79 and confirmed precisely what I've just stated. Paragraph 186 in the prosecutor's brief contains an allegation and a conclusion, according to which a report by Chief Perišić, which was submitted directly to the RS MOP, and it says in that report that the police expressed a lack of professionalism. They're referring to P633. I believe that this is very indicative and that it confirms the assertions of the defense. It is clear from the text that this is actually the first report that was ever sent to the RS MOP from Visegrad. It was sent in mid-July, to be more precise, on the 13th July. It was sent by courier, which means that there were no other means of communication. And this document confirms that the local authorities appointed the leading personnel of the SJB. And it says furthermore that there were only 5 active police officers there. That document also points to some serious problems that the SJB had with paramilitary groups. In paragraphs 368 through 373 of our final brief, we list all the measures that were undertaken by Stanišić and the RS MOP with regard to that part of Republika Srpska. In the following paragraphs, namely 188 through 210, the prosecutor deals with Bosanski Samac. The defense deals with those issues in paragraphs 492 through 453, 578 through 579, and 614 through 622. 2 days ago, Mr. Demidjan, on page 27307 of the transcript, spoke about mass killings, and he mentioned the murder of 80 people in Crikvina. A decision of this tribunal in the Simićatol case for crimes committed in Bosanski Samac, where I happen to be a counsel, so I'm very familiar with the case and the decision. In that decision, in paragraph 358, it is established that a total of 16 people were killed in Crikvina. The indictment in this case, Annex 10.1, charges the murder of 18 people in Crikvina. I suppose that the prosecutor misspoke, or that he made an unintentional mistake in the number. Paragraphs 228 through 250 deal with the municipality of Vlasenica. The allegations proffered in these paragraphs do not correspond to the contents of the evidence. During the proceedings, Your Honours, it was established, and ST179 testified about that he was appointed only on the 8th of August 1992 as the chief of the SJB. The fact is that before the 15th of May, he never even set foot in the public security station building because it had been attacked and taken over by paramilitary formations. When he arrived, he found a special attachment there as well as a reservist detachment. The allegation in paragraph 228, according to which the chief could report to his superiors in the CSB Sarajevo and the RS MOP about what was going on in the municipality, including the massacre in Drum and the beating at the SGB, is absolutely incorrect. The evidence referred to by the prosecutor testified to quite the opposite. ST-179 testified that he had started to reporting to his superiors only after he was appointed on the 8th of August 1992, which means nearly 4 months from the start of hostilities in the municipality. The allegation presented in paragraph 236 of the prosecutor's brief, where it says that when he was pressed, ST-179 agreed that the police detachment that he had found there had been established pursuant to Stanisić's order of 15 May. But this is incorrect. The witness on several occasions during his testimony stated that that unit had been established by the crisis staff, and that pursuant to a decision by the crisis staff, it was attached to the SJB, which neither him nor Bjelanović accepted, and that is on transcript page 7458. In paragraph 234, the prosecution claims, on the basis of evidence, that that unit was established immediately after the takeover of Vlasenica, i.e. in April 1992. So it remains indeed unclear how come that the prosecution concluded that it had been established based on the order that was issued on the 15th of May, which did not even exist at the time. It was established 1 month prior to that order. There is no proof that any information about the crimes committed by this unit was ever sent to the RS MOP. Your Honours, I'm looking at the time. The time is running out. I'm going to skip a few municipalities that have been dealt with in our final brief, and I will speak shortly about the municipality of Brčko. I'm talking about paragraphs 302 through 325, and the relevant paragraphs of our issue are 328 through 330 and 347, 348, and 492 of the defense brief. In paragraph 315, the prosecution claimed that Goran Jelicic was a reserve policeman. You will remember, I hope, that during my opening statement I suggested to Ms. Korner that the decision over this tribunal in the Jelicic case did not establish that he was a member of the RS MOP. The day before yesterday, Mr. Demirjan showed some photos from Brčko on page 27308, and he said the policeman killed 3 civilians in the middle of the street without stating the name of that policeman. Your Honours, those are notorious photos depicting Goran Jelicic. He documented his crime for posterity, and he was convicted by this tribunal for this crime. It's very hard for me to believe that the prosecution doesn't know that. However, this is just yet another example how the prosecution case is built without any context. The prosecution relied on some lists of the alleged reserve policemen, and we don't know who made those lists, when they were made. Your Honours, numerous witnesses during the proceedings testified about the general mobilization, and they said that chaos reigned supreme, that everybody who had some clout or knew somebody in the municipality would be put on the list of the alleged reserve policemen in order to avoid being sent to the front line. This is only logical and understandable. Even the well-known criminals and psychopaths such as Čelo, Prazin on the one side, and on the other side Jeličić and Česić found themselves on such lists. Now, what does that have to do with the MUP of Republika Srpska? Because the MUP of Republika Srpska does not have those lists, that the MUP does not have even criminal records of these people because they were destroyed. This is not the kind of evidence that the trial chamber can rely on. Another example is paragraph 321, where the prosecution alleges that the bulletin of the RS MUP of the 6th of May reports that there was fierce fighting going on in Brčko. However, the evidence points that civilians were being killed and not soldiers, and as reference, it states P142. If you look at that piece of evidence, and I kindly ask you to do that, you will see that it says here that the only claim there that there was fierce fighting going on, and that's all. Furthermore, the prosecution claims that the MUP ignored and covered up the killings of non-Serbs in the same paragraph. However, witness Ignić himself, that the prosecution refers to, claims that on the order of the chief of police, he performed forensic analysis of the bodies and made records of that, and you will find this in Exhibit P144. He also confirmed that there were investigations of those crimes, and you will find that on transcript page 1872. So this is yet another case of incorrect and incomplete presentation of overall evidence. Paragraph 325 is where the prosecution claims that Avliš was told only about 226 bodies, and furthermore, according to Ignić's testimony, that was an attempt of the SJB Brčko to cover up a mass murder of non-Serbs, and that the SJB Brčko did not give him anything with which he could carry out the forensic examination of the victims. This is incorrect. Namely, the evidence speak about the opposite. Namely, P393 is indeed Avliš's report that he drafted in October 1992. And it says in that report that due to the alarming information by the ICRC that in Brčko there were allegedly 2,500 bodies, Avliš checked the situation and he was able to establish that there were 226 bodies that had been buried, and the documentation on the death and identification was kept, and he suggests that the documentation should be submitted to the ICRC, and if the international organization demanded that, exhumation should be carried out. The information about 226 victims, which was presented in October 1992, fits in with P146, where witness Ignić recorded up to mid-July 1992 a total of 216 bodies. Ignić was not shown P393, and he never provided any comments on that exhibit. However, the witness confirmed on transcript page 1921 that the forensic examination was not done by the book, but that was due to the war. Therefore, the OTP's conclusion that this was an attempt on the part of the SJ Brčko to cover up a mass murder is not correct, because it is not corroborated by evidence. Never after that, information about 2,500 victims in Brčko was either repeated or verified, i.e. the information was false.
Časni sude,
Your Honor, I will now skip a few paragraphs and I will go to page 38. I'm saying this for the benefit of the interpreters. When it comes to the implementation on the regional level, the prosecution deals with the CSB Sarajevo, and we deal with this issue in our final brief in paragraphs 472 and 476. The allegation presented here about the CSB Sarajevo, this is the prosecutor's claim, according to which the CSB Sarajevo mostly had good communication with the subordinated SJBs, is absolutely incorrect, as may be concluded from the overall evidence. This statement arises from the report from October 1993, where it says literally that communication had been established with all SJBs, but that was only 6 months after the beginning of hostilities. I will revisit this issue when I talk about communications. In paragraphs 555 through 561, the prosecution says that crisis staffs functioned as the coordinators of municipal authorities, the SDS, the central Republican bodies, and the VRS, the police, and other forces as well. Our detailed explanation on this issue may be found in paragraphs 189 through 196, and 595 through 613. Again, this conclusion is erroneous because the instruction for the work of the crisis staffs, which was issued by the government, which is 570, puts an explicit ban on ordering the army and the police. Many witnesses, including the Prime Minister, the Deputy Prime Minister, the War Commissioner, asserted that the crisis staffs were the biggest problem and an obstacle to the functioning of central authorities, and that they did not have any control whatsoever over them. It is for that reason that they were soon to be abolished, or rather there was a proposal for their abolishment. When that failed, they were transformed into war presidency. Only 10 days later, they were transformed into war commissions, and for the first time, commissioners were appointed by the president of Republika Srpska. And this all obviously points to the fact that everything was done in order to establish control. So that the president of Republika Srpska could intervene. Further on, in the following paragraphs, the OTP obviously ignores evidence and laws, lists all the decisions of the bodies which they passed in keeping with their constitutional authorities, and the OTP treats them erroneously as one part of the implementation of the plan. For example, in paragraph 559, the prosecution alleges that the National Council of Defense was the predecessor of the presidency of Republika Srpska. This is not only
absolutely incorrect and arbitrary. But one could establish beyond any reasonable doubt, if the prosecution only wanted to open a constitution of Republika Srpska, if not the other regulations. Within this chapter, as part of the implementation of the plan, the prosecution mentions the decisions such as the selection of the vice president of the government, the decision on the establishment of civilian and military corps, and so on and so forth. This suggests that the Republika Srpska was the result of a criminal enterprise and not the expression of legitimate needs and interests of the Serbian peoples, as was finally confirmed by the international community and the Dayton Accord.
Your Honors, as I will be moving on to the criminal liability of the accused under his participation in the JC, I suggest that we take the break now, perhaps 3 minutes early, so that I can continue after the break. Thank you.
I did not interrupt Mr. Zečević at the time because I take the view that you should wait until there is a break. Your Honour, while a certain amount of hyperbole is to be expected and not to be commented on, Mr. Zečević this morning said, and I'm just going back to, I believe it's page 12, sorry. Yes, Your Honours, it's page 12, line 1. The prosecution engages in an impermissible speculation in this case in view of the facts. The prosecution are oblivious to the fact that although the trial chamber repeatedly called on them to disclose previous statements or interviews of the viva voce witnesses, the OTP refused to do so, unlike the defence, who disclosed all the interviews and statements of defence witnesses to both the prosecution and the trial chamber. Leaving aside the true situation, Your Honours, what is being suggested here that we have deliberately flouted a trial chamber order to disclose. We therefore ask for chapter and verse rather than these vague and utterly, we say, impermissible statements. Once there are other matters, I'm not seeking to, at the moment, try for rebuttal, but this matter is too important, we say, to leave. So we ask for chapter and verse.
Well, in a similar vein, Ms. Corner, when Mr. Zečević was making those representations, he seemed to be criticizing the decisions of the trial chamber in terms of the admissibility of certain evidence, and it's something on which the trial chamber either would have spoken and made a decision, and therefore the parties are bound by it, or it is something which they could have sought to appeal and didn't. I was going to intervene, but inasmuch as just as with the criticism that you have identified in terms of what the prosecution would have done, he left that area and didn't return to it. So I said nothing further about it at that point. But in terms of the specific, and to use your words, the almost inevitable, although unfortunate, hyperbole which one tends to expect in closing arguments, the prosecution having challenged this assertion, which of course is on the record, at some point I expect that Mr. Zečević, that you would either support it or withdraw it. So we take the adjournment to come back at 11:50.
All right, we will